right from access to justice concerns to the extent of the matters that are the mandate of that court to deal with. And what we are also submitting is that practically it may not even be possible to complete the process of removal of the Supreme Court judges if the same court is rendered dysfunctional. Because one of the very inherent protection or guarantees accorded to persons going through that process is that they are at liberty to challenge the decision of the tribunal at the Supreme Court. So if at the very instance the process disables or impairs functionality of that court, it means then practically that process can never be completed as constitutionally envisaged. So the crux of it is to see that the first respondent, as they process this complaint, they have to be aware of the threat of making Supreme Court dysfunctional based on the process that they've already taken in as far as simultaneously processing those complaints is concerned. So that guarantee is what the FIDA is here to push for and say first respondent needs to be aware of that and needs to take measures which must be communicated legally, lawfully, in a way that guarantees that functionality of the Supreme Court will not be affected. But as it stands, it remains a serious and a real threat. So just to clarify, that the petition does not venture into the merits or demerits of the specific complaints against the judges. Hence our position that it will not serve useful purpose to consolidate it with the other petitions by the specific judges of the Supreme Court.
I remember the last time we were here, the issue was sort of any person who was supporting consolidation.
Actually, it is the AG.
No,
the AG
my lord, my recollection is we fully ventilated.
Yes, sir?
We ventilated our respective views.
Yes, I remember.
And then the court said,
Yes.
elections,
Yes.
once you make a decision on the other related matters.
Yes.
So I think the mistake you did today is you listed this before the other matters.
Yes, we are supposed to
have dealt with, yes.
And then we deal with
You
it,
give
and
directions.
ruling at the end,
That was what was supposed to
We
happen.
give that to the ruling, we give direction.
Yes.
Yes. It's one which has a constant, but we still can go back into that. You can hold that up, we direct the ruling first.
Yes.
We can be able to look at that.
Okay.
Is it agreeable in any advocate with the contrary view? So, then we can have the quorum,
My name is James Okengo. I appear in this particular matter representing the Honorable Justice William Wuko, who is the fourth petitioner. I appear with Mr. Benson of the ward today. I already introduced the other councils.
I don't know who's behind the hearing. Can be a bit.
Yes, let me raise my voice.
Yes.
Now, Ms. Lukoye is holding brief. Sorry, Mr. James Chepkon is holding brief.
What you are for?
And for the fourth petitioner, Honorable Justice William Owuko. I appear with Mr. Benson of the ward. My Lord, if I may introduce the other councils. Mr. James Chepkon is holding brief for Mr. George Oral. For the first petitioner, Honorable Lady Justice Martha Koome, Chief Justice of the Republic of Kenya. Ms. Betts is holding brief for Mr. Andrew Musanga. For the second petitioner, the Honorable Lady Justice Joaquin Dumus, Judge of the Supreme Court. And you have Ms. Lukoye holding brief for Dr. Nyaundi. For the third petitioner, Honorable Justice Isaac Lenaola, Justice of the Supreme Court. And Ms. Lukoye is also holding brief for Mr. Malitzo for the 23rd Interested Party, Katiba Institute. Mr. Kip Kogei is appearing for the fifth petitioner, Honorable Justice Dr. Smoke Mwanjala, Justice of the Supreme Court. I believe Mr. Kemboy.
I'm present, my lord.
Kip Kogei is present. Now, anybody for Mr. Kemboy for the sixth petition? Looks like they're not here. And then Mr. Murugu appeared for the seventh petitioner, Honorable Justice Ibrahim Kadir.
Just a slight correction, Your Lordships. My name is Odiambo Isaac. I will be holding Mr. Murugu's brief today.
Thank you. For the seventh petitioner, Honorable Justice Ibrahim Kadir. Now, for the first respondent, we have Ms. Ahomo, Mrs. Ahomo, holding brief for Mansour Issa. For the Judicial Service Commission, I believe. And we have Mr. Emmanuel Bitter appearing for the second respondent, the Honorable Attorney General of the Republic of Kenya, who is the second respondent in the consolidated petitions. My lords, there are several interested parties. And we have Mr. John Kisigwa holding brief for Mr. Dennis Musota for the third, fourth, fifth, sixth, and seventh interested parties. Counsel John Kisigwa holding brief for Mr. Dennis Ben Musota for the third, fourth, fifth, sixth, and seventh interested parties. Now, I do not see anybody who's holding brief for Nelson Havi. Anybody holding his brief? Looks like there is nobody for Mr. Nelson, and he's not here. Now we have Ms. Gishere holding brief for Mr. Kiragu Wadrita for the 22nd interested parties, KMJA. Then we have a Ms. Modoni holding brief for Mr. Ahmed Nasser, Senior Counsel, for the 14th and 15th interested parties. Although that's all, unless somebody who's holding brief.
My lords, good morning. Miss Malay, I'm holding brief for Mr. Nyamodi for the 21st and for the 20th and 21st interested parties.
20?
For the
16th and 18th interested parties.
No, there's also the 20th.
And the 20th?
And Ima.
All right. So, for the 16th, 18th, 20th, and 21st interested parties. My lord, I believe that's all as far as the presentation is concerned.
Justice Bahati is starting the first part of it.
Alternatively, to have permitted the impaneling of the bench through an impartial and transparent mechanism. The applicant's position is that the failure by the Honorable Chief Justice to so recuse herself and to ensure an impartial bench assignment process rendered the proceedings incurably defective from inception, thereby vitiating the legitimacy of this bench and engendering a reasonable apprehension of bias in favor of the petitioners. The first interested party applicant noted that each of the 3 honorable judges on this bench had previously handled interlocutory applications in some of the consolidated matters before their consolidation, with 2 of the judges proceeding to issue conservatory orders favorable to the petitioners. The applicant submits that by granting such orders, the judges had, and I quote, had each already pronounced themselves, close quotes, to some extent on issues in dispute, and thus a fair-minded observer might question their impartiality in the final determination. Secondly, the applicant argues that Honorable Mr. Justice Lawrence Mugambi and Honorable Mr. Justice Bahati Mwamuye are relatively junior judges appointed to the High Court during Chief Justice Kome's tenure as chair of the Judicial Service Commission, with Mugambi judge having been sworn into office in December 2022, while Mwamuye judge was sworn into office in May 2024. Mr. Nelson Havi argued that these 2 judges, and I quote, are perceived to be beholden to the Honorable Chief Justice, close quotes, due to the fact that they were interviewed, recommended, and appointed as judges during her ongoing tenure as the Chief Justice. Although no personal misconduct is imputed to the judges, the applicant argues that the objective perception of their perceived loyalty or perceived indebtedness to the Honorable Chief Justice cannot be ignored, given human nature and career dynamics. Thirdly, the applicant contends that the Honorable Chief Justice, in selecting this particular trio of judges, allegedly failed to take into account the essential considerations of expertise, experience, and diversity, contrary to established practice and precedent. It is argued that the 3 judges are relatively new to the bench, and none is especially known for expertise in complex constitutional adjudication or the subject matter at hand. It is further argued that the impanelment does not reflect regional, professional, or gender diversity, and it included no, and I quote, senior judges or peers, close quotes, of the petitioners, contrary to the historical trend in matters involving senior judges. In the applicant's view, a bench of 3 relatively junior judges who owe their recent appointments to the Chief Justice gives an appearance of a hand-picked team that may tilt in favor of the petitioner judges. The parties in support of the application placed substantial weight on the recent Court of Appeal decision in His Excellency Rigathi Gachagua and 5 others versus Thomas Kimotho Maingi and 80 others, 2025 EKLR, which dealt with a Chief Justice's role in bench assignment. In that case, the Court of Appeal outlined some of the factors that a Chief Justice should possibly consider when impaneling a bench under Article 165, Clause 4. The appellate court stated those factors include, and I quote, selecting judges with varied legal philosophies, regional representation or professional backgrounds, prior involvement in related matters, the sensitivity of the case and the corresponding need to uphold public confidence in the judiciary, avoidance of conflicts of interest to ensure impartiality, and of course, the workload and ability of the proposed judges, close quotes. The applicant argues that the Honorable Chief Justice's impanelment of the current bench deviated from these principles, particularly the avoidance of conflict of interests and ensuring public confidence. The party supporting the application further observed that the Court of Appeal, in what has come to be referred to as the Gachagua case, pertinently posed a rhetorical question in the following terms. So what is to happen when the Chief Justice is, for whatever reason, absent, or when a matter certified as requiring empanelment relates to a matter where the Chief Justice is a party or substantially relates to the office or person of the Chief Justice? It was submitted by the Court of Appeal it was submitted that the Court of Appeal proceeded to answer that question by reference to comparative Commonwealth practice and judicial precedent. In particular, reliance was placed on the decision in Leina Conchella and others versus Chief Justice of Kenya and others, 2021, KEHC 12609 KLR, wherein Chief Justice David Maraga, upon being named as a respondent in those proceedings, duly and appropriately delegated the function of empaneling the bench to the then and current Deputy Chief Justice, Honorable Lady Justice Philomena Mwilu. The applicant drew the court's gaze to the decision of the UK Privy Council in Yakub and another versus the Queen, 2014, UKPC 2022. In that case, the presiding judge appointed a judge to an appellate panel that was to hear an appeal from the presiding judge's own first instant decision. The UK Privy Council held that the impugned action carried an unacceptable appearance of bias, observing that, and I quote, appointing a judge to hear an appeal from himself carries an appearance of lack of independence and impartiality, which would impact on an objective informed observer. Close of quotes. By analogy, the applicant argues that the Honorable Chief Justice's action of constituting a bench to hear and determine a case in which she is the petitioner is indefensible in light of the persuasive precedent of the UK Privy Council decision in Yakub. The applicant concluded by pointing out that the UK Privy Council quashed the impugned proceedings and directed that a new panel be constituted by the next most senior judge who was not involved in the matter, and the applicant sought that the same applies in the present scenario.
The application is under parties. In omnibus, the parties opposed characterize the application as conceived. The application is driven by extraneous motives, possibly to delay the hearing of the petition or to engineer a more favorable bench. A preliminary objection raised by the sixth respondent is that the application is barred by doctrine of res judicata. And counsel for the sixth petitioner points out that this very issue on whether the first petitioner could lawfully empanel the bench to hear her case was raised, argued and conclusively determined by the High Court in a ruling delivered on 25th April 2025 by Honorable Mr. Justice Lawrence N. Mugambi. In that earlier ruling, the court found that the Honorable Chief Justice could lawfully empanel a bench, notwithstanding her status as a petitioner in Milimani High Court Constitutional Petition number E083 of 2025. The sixth petitioner observes that the present application is not in the nature of an application to review the ruling dated and delivered on 25th April 2025 by Honorable Mr. Justice Lawrence N. Mugambi, nor can this High Court sit in an appeal of that decision of that High Court. Accordingly, the sixth petitioner argues that substantive issues, while closely related and somewhat intertwined, have sufficient unique aspects for them to be formulated, analyzed, and determined distinctively. Analysis and determination. Issue number 1. Whether the consolidated issues hearing should be remitted to the Honorable Chief Justice for re-empanelment by Her Ladyship the Chief Justice or Her Ladyship the Deputy Chief Justice. Upon a careful perusal of the issues raised for determination, the submissions of counsel, and the constitutional and statutory framework governing the empanelment of benches under Article 165 of Article 4 of the Constitution, this court is satisfied that the question before it has been conclusively settled, and thus it is functus officio in respect thereof. It is not in dispute that by a ruling delivered by Honorable Justice Bahati Mwamuye on the 10th of April 2025 and Honorable Mr. Justice Lawrence Mugambi on the 25th April 2025, the respective judges, having heard the parties, certified that the petition before them raised substantial questions of law within the meaning of Article 165 sub Article 4 of the Constitution. Consequently, and in compliance with the dictates of that provision of our supreme law, they refer the matters to the Honorable Chief Justice for empanelment of a bench comprising of an even number of judges, being not less than 3, to hear and determine the petitions. Pursuant to the said judicial certifications, the empanelment was duly undertaken by the Honorable Chief Justice in exercise of a constitutional discretion under Article 165, Sub-Article 4. The Court of Appeal, in Rigathi Gachagua and 5 others versus Thomas Kimotho Maingi and 80 others, 2025 EKLR, lucidly articulating the prevailing legal position as follows. Open quote. The role of the Chief Justice in setting up a bench under Article 165.4 is triggered by a matter being certified by the High Court or the Court of Equal Status as raising a substantial question of law under clauses 3, B or D of the said article. Once the court certifies that a matter qualifies to be heard by an expanded bench, the Chief Justice cannot question that decision. Anyone aggrieved by the certification has a right of appeal to the Court of Appeal. End of quote. Or closing quote. It is therefore beyond contestation that once certification was made and the Chief Justice undertook empanelment pursuant thereto, the process attained finality. The proper recourse for any aggrieved party lay in an appeal against certification decision. No such appeal to the Court of Appeal has been preferred. To now invite this bench to revisit, reopen, or remit the matter to the Chief Justice for fresh empanelment would amount to an impermissible attempt to re-exercise a jurisdiction that has already been spent. The Supreme Court, in Raila Odinga and 2 others versus Independent Electoral Boundaries Commission and 3 others, restating the doctrine of functus officio in the following paragraphs. Open quote. Daniel Malani Pretorius, in the origins of the functus officio doctrine, with specific reference to its application in administrative law, 2005, bracket 2005, 122, SALJ 832, explicates this concept thus. The functus officio doctrine is one of the mechanisms by which the law gives expression to the principle of finality. Once such a decision has been given, it is, subject to any right of appeal, final and conclusive. Such a decision cannot be revoked or varied by a decision maker. End of close quotes. Similarly, in Jersey Evening Post Limited versus A.I. Thani, 2002, JLR 542 at page 550, it was held that, open quote, a court is functus when it has performed all its duties in a particular case. The purpose of the doctrine is to provide finality. Once proceedings are finally concluded, the court cannot review or alter its decision. Any challenge to its ruling must be taken to a higher court. Close quotes. Guided by the foregoing authorities, it is manifest that the High Court, having certified the matter under Article 165 sub-Article 4, and consequently caused the empanelment to be affected, the court has fully discharged its jurisdiction in that respect. The High Court cannot now recall, or revisit, or relimit the matter to the Honorable Chief Justice for recertification or reassignment. To do so would not only offend the doctrine of functus officio, but also undermine the principle of finality that undergirds judicial proceedings. As to the contention that the Honorable Chief Justice, being the petitioner in Milimani High Court Constitutional Petition number E083 of 2025, and a conflict of interest, and therefore ought to have delegated a constitutional mandate under Article 165 sub-Article 4 to the Honorable Deputy Chief Justice, this argument is equally misconceived. The Court of Appeal, in Gachagua and 5 others, at paragraph 145 to 155, examined the scope of Section 5, subsection 4 of the Judicial Service Act and held that the Deputy Chief Justice may only act as Chief Justice in 3 defined circumstances, namely removal, resignation, or death of the Chief Justice. The court emphatically stated that the Deputy Chief Justice cannot act as a General Deputy, save in those exceptional and demonstrable instances. Accordingly, neither the mere fact of Honorable Chief Justice being a party to proceedings nor the perception of conflict constitutes an exception contemplated under the law. the Constitution vests the empanelment power exclusively in the Chief Justice, and that discretion cannot be usurped, directed, or fettered by any court. Indeed, as the Court of Appeal further held in Gachagua at paragraph 213, open quote, the discretion granted to the Chief Justice by Article 165, sub-Article 4, to empanel a bench is a power solely granted to the Chief Justice. It is the Chief Justice, and she alone, who can decide the number of judges to assign a matter. Similarly, it's only the Chief Justice who can decide which judge to assign to a bench, end of quote, was closing quote. In light of the foregoing constitutional, statutory, and jurisprudential framework, this court finds that it is functus officio in respect of the certification and empanelment of the present matter. The question of referring the same back to the Honorable Chief Justice for the empanelment does not arise. Any grievances regarding the empanelment or the composition of the bench can be ventilated through the appropriate appellate process. Accordingly, the court holds that the empanelment was validly undertaken pursuant to Article 165, sub-Article 4 of the Constitution, that the court's jurisdiction on the issue has been fully and finally exercised, and that no order may now validly issue from the High Court purporting to direct or compel the Honorable Chief Justice in the discharge of our constitutional functions under Article 165, sub-Article 4 of the Constitution. I now...
Yes, issue number 2, whether the legal grounds for the recusal have been established. The instant matter, the first interested party submitted the consolidated petition to the Chief Justice for the reassignment. The fundamental question that arises is, has the threshold for the recusal of the bench been met by the first respondent party? The right to fair hearing under Article 50, sub-Article 1 of the Constitution, and its cause independence and impartiality is a critical principles that must be insulated to protect the judicial decision-making process from bias, external influence, or the prejudices. Article 50, sub-Article 1 state, quote, every person has a right to have any dispute that can be resolved by the application of the law, decided in a fair and public hearing before a court, or, if appropriate, another independent and impartial tribunal or body, close the quote. Pursuant to Section 47 of the Judicial Service Act, Regulation 21, 1 of the Judicial Service Code of Conduct and Ethics, regulations was formulated. This regulation provides for the various instances when a judge may be required to recuse himself or herself from a judicial proceeding. It states, quote, a judge may recuse himself or herself in any proceedings where their impartiality might reasonably be questioned, including where the judge A, in a party to the proceeding, B, was or is material witness in the matter in controversy, C, has a personal knowledge of the disputed evidentiary fact concerning the proceedings, D, has actual bias or prejudice concerning a party, E, has a personal interest or is in a relationship with a person who has personal interest in the outcome of the matter, F, previously acted as a counsel for a party in the matter, G, is precluded from hearing the matter on account of any other sufficient reason, and H, has family member with an economic or other interest in the outcome of the case. Close the quote. Nevertheless, it must be appreciated that this does not mean that these are the only circumstances a judge should recuse himself or herself in a matter. As stated by the Supreme Court in Rai and 3 others, Keza, 2013 KESC 20 Kenya Law Report, quote, the circumstances calling for a recusal for a judge are by no means cast in stone. Perception of fairness, of conviction, of moral authority to hear the matter is a proper test of whether or not the non-participation of the judicial officer is called for. The object in view in the recusal of a judicial officer is that justice is between the parties be uncompromised, that due process of the law be realized and be seen to have and had its role, that a profile of the rule of law in the matter in question be seen to have remained uncompromised. Close the quote. In our view, the threshold of the recusal was aptly laid down by the Court of Appeal in the case of Raoul for the Judicial Service Commission and another, for Koiti, Interest Party, International Commission of Jurists, and another, Amicus Curie, 2016 KECA 534 Kenya Law Report, which citing the decision of the Supreme Court of Canada held that the Supreme Court of Canada expounded the test of the following terms in R versus S, in brackets RD 1977, 3 SCR, the 484. Quote, the apprehension of bias must be reasonable, one held by reasonable and right-minded persons, applying themselves to the question of obtaining thereon the required information. The test is what would an informed person, viewing the matter realistically and practically, and having thought the matter through, conclude. This test contains a twofold objective element. The person considering the alleged bias must be reasonable, and the apprehension of bias itself must also be reasonable in the circumstances of the case. Further, the reasonable person must be an informed person, with the knowledge of all the relevant circumstances, including the traditions of the integrity and impartiality that form part of the background, and apprised also of the fact that impartiality is one of the duties the judges swear to uphold. The reasonable person should also be taken to be aware of the social reality that forms the background to a particular case, such as societal awareness and acknowledgement of the prevalence of the racism or gender bias in a particular community. The jurisprudence indicates that a real likelihood and probability of the bias must be demonstrated, and that a mere suspicion is not enough. The existence of a reasonable apprehension of the bias depends entirely on the fact. Threshold for such a finding is high, and the onus of demonstrating bias lies with the person who is alleging its existence. Close the quote. That is the tests we propose to adopt in this application, as it is accepted test. Do the grounds relied upon by the first interested party meet the above test? Firstly, none of the said ground relied upon by the first interested party in his application for this recusal that specifically falls within the range of the circumstances specified upon under the Regulation 21(1) of the Judicial Service Code of Conduct and Ethics Regulations, meaning the statutory test was not established. Having failed the obvious and the more direct test, the next limp is to consider whether alleged apprehension or bias by the first interested party is reasonable in the circumstances of this case. The Constitution of South Africa, in the President of the Republic of South Africa and others for the South African Rugby Football Union and others, 1999, articulated the test for the apprehension of bias thus, quote, the question is whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case. It must be assumed that the judges can disabuse their might of any irrelevant personal beliefs or predisposition. They have a duty to sit in a case in which they are not obliged to recuse themselves. Similarly, the Supreme Court, in the case of Gladys Bush Soleil, as the Judicial Service Commission and another, 2018 Kenya Law Report, citing the case of Simpson General Motors Corporation, USDC 425 R sub 574 578, 1978, emphasized the duty to sit, stating that, quote, recusal, reassignment is not a matter to be lightly undertaken. While in proper cases, we have a duty to recuse ourselves, we have a concomitant obligation not to recuse ourselves. Absent valid reasons for recusal, there remains what has been termed as a duty to sit, close the quote. The obligation to demonstrate there exists reasonable apprehension of bias is essential so as to safeguard judicial independence by ensuring that judges do not recuse themselves on flimsy grounds, and that litigants cannot, through speculation and pressure, manipulate the composition of the court. We have carefully assessed each and every allegation made against this bench and we find nothing but unsubstantiated allegations that are devoid of any evidentiary or legal basis. The allegations range from regional and gender composition of the bench, perceived and inexperience by members of the bench to handle complex constitutional questions, that two of the judges had and granted conservatory orders in favor of the petitioners here, hence have formed their mind, that two of the members of the bench were appointed during the tenure of the Chief Justice, who is the petitioner, hence beholden to her, and so on. In our humble view, these are mere sensational allegations that have no bearing on the impartiality of the bench. To act on such allegations will subvert the integrity of the institution and the constitutional obligation imposed upon judges to discharge their duties without fear or favor. The argument advanced by the first interested party with regard to his perception that the judges of this bench are relatively junior can be easily ascertained by reference to the seminal decision of the Court of Appeal in the case of Bat versus Rent Restriction Tribunal, 1979 E-Kenya Law Report, in which the court famously held that, quote, a judge of the High Court has the same jurisdiction and power as any other judge of the High Court. There are no senior or junior judges in the High Court. All are equal in jurisdiction and authority, close the quote. Accordingly, any suggestion that the judges constituting this bench lack the requisite seniority or expertise or experience to sit together is totally misconceived and without merit. All judges of the High Court derive their authority from the same constitutional source. Article 165 and exercise coordinate jurisdiction. The grounds advanced do not satisfy the statutory or jurisprudential standards for recusal. All judges of the High Court enjoy equal constitutional standing, and this court finds no reason to send the consolidated petition to the Honorable Chief Justice for a certification or impanelment. Issue number 3 is the cost. This court has no reason to find that the application, where unsuccessful means meets any of the criteria that would require the unsuccessful applicant to bear the costs of the application. Noting that the consolidated petitions here touch on matters of public interest, we find that it is fit, right, and proper that each party bear its own costs in the application. So the final orders, for the foregoing reasons, the first interested party's notice of motion application dated 9th June 2025 is found to be without merit and is dismissed accordingly, with each party to bear its own costs in the application. The court will also, after delivery of this ruling, proceed to issue comprehensive direction towards expedited hearing and determination of the consolidated petitions herein. Those are our orders at long and short of this ruling.
Much of luck, and also on behalf of all councils, we are grateful for actions on the consolidated petitions.
directions on the filing and the replies and the timelines.
Yes.
In fact, it was just stopped because of the direction of hearing when you had to submit. When the application came in, this one we have ruled on.
Yes.
So maybe what we can confirm whether all the parties had found their replies and whether there was anything else to be filed on that part, so that you can now go to the next step. Because we have to get a date for submissions.
Yes.
For the that is highlighting of the submissions, isn't it?
Yes.
That's the position we had reached before we came to this application hearing.
My Lord, I'm informed that there was a replying affidavit that was filed
Yes.
by the first interested party, to which I think most of the petitions would wish to actually file a response.
Yes.
So there was a recent development that needs to be addressed in light of that filing. On behalf of the fourth petitioner, I inform the court that we'll be uploading our submissions by close of business today.
Okay.
The petitioners are granted leave to file and serve supplementary written affidavits responding to replying affidavits filed and served, together with written submissions, and they shall do so within 14 days from the date hereof. The respondents and interested parties shall file and serve their respective written submissions within 14 days of last service by the petitioners. The petitioners shall have leave to file and serve rebuttal written submissions if need be, and they shall do so within 14 days of last service. The consolidated petitions shall be heard by way of highlighting of written submissions on 13th February 2026 at 9:30 a.m. in physical/open court. Courtroom number to be indicated on the day's cause list. In order to ensure seamless hearing, the court directs that every party shall download all documents filed by the counterparties on CTS, but this shall not be a substitute for service, and service shall still be required. The first petitioner to extract these directions and serve them on all parties alongside service of the first petitioner's written submissions.
This particular matter, from adverse comments on social media, specifically by the first interested party. My Lord, this is necessary because it has become a habit that matters are being litigated on social media, thus interfering with the due administration of justice. I therefore seek that this honorable court be pleased to grant an order that pending the hearing determination of these particular petitions, no party is allowed to either air views on this particular matter on social media or even scandalize the petitioners in any way. My Lord, we still have the petitioners as distinguished judges of the Supreme Court, and this practice ought to be stemmed because it's becoming a point of concern. Judicial processes and judicial authority is vested in the courts under the Constitution and nowhere else. So to assume a stance whereby social media is a substitute for judicial processes is something that should be highly discouraged. I humbly submit. And my Lord, in light of the importance of this particular matter, which touches on the apex court, we seek an expedited hearing and expedite the determination of this particular matter. I humbly submit.
Counsel, would the 27th of February work?
Yes, it's fine.
Anyone for whom 27th of February is not convenient? Okay. So the consolidated petitions shall be heard by way of highlighting of written submissions on 27th February 2026 at 9:30 a.m. in physical/open court. Courtroom number to be indicated on the day's cause list.
Okay, now I will give directions. The petition will be heard alongside petition E083 of 2025, but distinctly as a separate petition from E083 of 2025 by this bench. In the circumstances, the directions are given as follows. The petitioner to file and serve written submissions to the petition within the next 14 days.
Counsel Marori had requested if the petitioner could be accorded 30 days.
The next 30 days. And upon service, the respondents will also have a similar period, that is 30 days from the date of service of petitioner submissions. The petitioner will have the liberty to file rebuttal closing submissions within 14 days from the date of service of the respondent submissions. And we are thinking that it might not be possible to hear these two petitions together. That is for purposes of highlighting. So we are proposing that you come back on 20th of February.
20th of February?
Yeah, 2026.
Yes, it is convenient.
All right, thank you.
Most obliged.
But the aspect which was raised, matters raised by the view that so that you can set out the clear complaint and the aspect which is being or the area which complaint is touching, you can have a form application so that those concerned can be able to respond and justify or defend themselves. Of course, I have seen even when I'm doing matter in Narok, there's a lot of accusation and many very bad things said about me and the party. But he won't to entertain him because when we tried to interrogate him, he disappeared from the court that time. We want him now to come and defend whoever is. I'm not specifically saying that, but I'm talking specific, it happened. But that litigating the matter in the social media and maligning the parties and advocates, of course, is actionable. But to safeguard the integrity of the proceedings and also the parties and advocates, it is better you do an application so that we have a clear order which will be enforced in terms of contempt if cases violated. We set the parameters.
Maybe just to add a bit, it is important that you, as you do so, you also attach whatever makes you to make that complaint so that the court can have a look at it and also form its own opinion.
You're most obliged.